Right. I am Serena. I'm a medical student here at Hong Kong U, and I'm joined with Professor Jerry Menikoff, a professor here at the NUS Center for Biomedical Ethics. Welcome.
My pleasure to be
Right.
here.
I would like to start off the interview by asking you, you joined us on the Unit 731 trip last summer. Is that right?
Yes.
What do you think of the trip? What is the most remarkable experience you have?
Yeah, it was an amazing trip. Yes. So I'm involved in research ethics,
Right.
and certainly one of the huge issues in research ethics, historically speaking, is going back to what the Nazis did, in terms of World War II, and concentration camps and that sort of thing. And it's interesting because, the Nuremberg Code, which came out of the trials of researchers that were conducted after the end of World War II, is one of the major, events that happened that led to our current rules in terms of protecting research subjects. And, so I teach a lot about that. I think about it. I even will tell students that I think the Nuremberg Code, which is wonderful as a ethics document because it's actually short.
Right.
And it is like 10 little, for 9 of the 10 provisions, they're like a sentence long.
Mm-hmm.
And then the real long one is the first one, and it's about consent. And I happen to think consent is actually the most important part of research ethics. So they got a lot right. It's a really wonderful document, and precisely because it's so short, people can actually study it and not get bogged down in having to read pages and pages of stuff. Okay,
Right.
So that all comes from what the Nazis did. And then you now learn that, the Japanese did something kind of similar in terms of horrible types of research that they did on Chinese and some other people during World War II. And that's far less well known. And I even say that as a person who, my field is research ethics.
Right.
And I was vaguely aware that, yes, the Japanese did some, horrible stuff during World War II, but I didn't know much about it. And then I was invited to participate in this course. And from my viewpoint, I was, very excited to be able to learn, what actually happened. And in fact, I teach a research ethics course here at NUS. And my predecessor in the course, because I picked it up from somebody else, he had the materials for the course because he originally put it together. And on the very first page of the course materials was this picture of this building. And I kind of vaguely knew, I bet this has something to do with the Japanese research activities,
Right.
but I didn't really know that. And then when I went on the actual course and the trip, we went to the real building, which actually exists. And so that was so incredibly cool.
I do understand that. The very first moment I saw that building, I've only seen it in books before that, and it's right in front of me. And
Right.
all the, things that happened there just kind of, rushed to me. And I feel like that's a very humbling experience. And I really appreciate the design of that museum. I don't know if you remember, in the front of that museum, there's a huge black stone pledge kind of thing that in white words wrote the name of the museum. And then inside the museum, it's this huge hall with the Chinese version of the Declaration of Helsinki and the Nuremberg Code on the wall. And it's just it's very well designed. It brings up a very heavy message.
Absolutely. It's a wonderful museum. And yeah, exactly. You have the same feeling when you're there and knowing what happened. The other part of it is, as you know, that the Japanese went to great efforts to destroy all the buildings, at the end of World War II when they knew they were going to be surrendering soon, whatever it is. And they were hard buildings to destroy. Apparently they had to use explosives many, many times. But next to the building and the museum that we're talking about, right, you have this largish compound, which is basically, glass walls and a roof over the remains of the buildings, basically just the structure at the bottom or something, the support structure. And they let you just walk around that and see what remains of those buildings, because that's all that is there, sort of this large pit with, concrete and everything. And even walking around that, they kind of give you little pictures of what it was like when it was actually there and everything. But they did a really, really nice job. It is interesting how so much of your emotions, apart from being in the museum where it has lots of details on what actually happened, but the other parts, you know, the destroyed buildings and even what we did during the course in terms of going to suburbs and seeing some places where people were killed, but there's not a lot to remember there except for, you know, little markers. The emotions you go through, right, just in terms of in your mind having to reconstruct what happened because you're in front of something that doesn't look particularly unusual and it certainly doesn't look horrifying in any way. You're in a field or you're in one of the places is this like junkyard that has like
Right.
you know scrap metal and things like that. And so yeah, it was a very moving experience. And again, you know, from my viewpoint as somebody who teaches about research ethics, it raises this whole question of why around the world in general in this field we pay so much attention to what the Nazis did, and we rarely, you know, particularly I think outside of Asia, talk about the events that took place in China and what the Japanese did.
Yeah, I think a huge focus of our project on 731 is on experiential learning, because I really think that bringing students to the site where things happened gives off a much greater impact than just giving it a lecture in a lecture hall talking about, you know, history. I think experiential learning has been a thing for, you know, the Holocaust for a while. They bring students, medical students, to Auschwitz and all the concentration camps, and it has been proven to be very effective in teaching ethics. And I feel like the same thing could be, you know, reapplied here at 731 as well. Yeah.
Absolutely.
And about the
Totally
suburbs, I remember the first time me and Zora went there, it took us a long time to find out where that particular
Where it
scrapyard
is,
is
right.
because there's no marker, nothing.
Yeah.
And then we asked around the villagers, and a lot of them don't really know the story anymore. So I feel like it's, you know, it's important to kind of keep this in history, especially because a lot of the evidence has already been destroyed. A lot of the victims are already, you know, not with us anymore. So it's very difficult to get testimony of any sort. Yeah, that's true. I know you're involved in research ethics teaching here in US. What do you think? Do you think it's effective to use historical case examples to teach ethics?
Oh, absolutely. Yeah. I mean, it picks up on what you're already saying. You get more emotionally involved because, you know, these are actual stories of things that, you know, certain people did horrible things, and then the people that all these horrible things happened to. I used to, back when I was in the U.S., I kind of co-ran an ethics program at a U.S. university, and my colleague was what they call a narrative ethicist. And in narrative ethics, you tell stories, and sometimes they're just like not true at all. They're just, you know, novels or short stories or whatever it is that people write. But when it relates to what actually happened, that could be incredibly moving, and I think it does motivate students. Many of my research ethics students, they're getting PhDs and they're not particularly interested in research ethics, but for whatever reason, right, they're required to kind of take a course in it. And right, giving them, you know, showing them a picture of, you know, right, the buildings that still exist in terms of Unit 731. It's something that just affects their minds and it gets them more interested so that they then think more about why we have this sort of, you know, these rules. Right. And, you know, why they're needed. So the connection to reality is huge, and I still think there are many stories to be told about Unit 731. We're back to, I think we're at like the tip of the iceberg in terms of how we learn from this event when you compare it to what we learned in terms of, you know, Nazis.
Definitely. When you talk about narrative ethics, it makes me think about using reflexive writing as, I don't know, assessment or any sort of gauging the engagement of students in research ethics. Do you do that with your courses as well?
Probably not that much. I mean, I assign them, writing exercise, but they're more sort of problem, you discuss a particular problem that you're told about, and they have to apply some sort of ethical analysis to that. And of course, these days, with ChatGPT and all of this gets more controversial because, in general, the rules around here are fairly generous in terms of allowing students to use that. So now you have to come up with ways to state the problems that they can't just have ChatGPT write the things for them, because it is very good when it writes these answers. Often it's like, wow, this writes much better than I could or something.
I think generative AI has its perks in giving you good summaries, but they often lack soul. And I feel like the essence of a reflection is really a personal thought, and I think that is something that ChatGPT just cannot replicate. But do you have any problems with engaging with students in these research ethics classes? Do you find them interested in the materials?
It probably depends partly on the individual students. Some students are more engaged than others. I try to make the material interesting. I try to make it down to earth so it fits with your take in terms of what's tied to historical. I do so often. Many of the other members of my department are more philosophically trained. They're philosophers. I don't have a huge amount of training in philosophy, so more of my training is as a doctor and as a lawyer. And so probably the lawyer part of me comes through more in terms of what I think is more of a contribution, particularly to making this course unique. And in terms of sort of the legal aspect of it, I like real problems in terms of, so for example, consent is a huge part of making research more ethical, and so I will give them all a protocol and a consent form to look at that I kind of sort of randomly pick, but that's a recent consent form, and we go through it. I mean, a lot of what I actually write about is looking at how we get consent in common clinical trials these days, and the problems we have with that, in spite of the fact that, going back to, Nuremberg Code and that sort of stuff, it's like, 75 years ago or so, you'd think we'd have this all right by now or something, yet from my viewpoint, and not just me, a lot of us think we don't actually do a wonderful job in terms of informed consent. And again, this is not, you don't have to be all that philosophical to figure this out. You just kind of look at some consent forms and you'll quickly discover the problems they have. When, this is going back to the first time I got involved in the field of research ethics was because I went to, it's the University of Kansas, it's in the middle of the US.
Yeah.
And I was at the medical school there. I was supposed to be taking over the position of another faculty member who happened to actually, he had cancer and he was dying. Fortunately, he didn't die immediately, so he actually had a few more years of life, and I was able to learn from him. But he was the chair of the Research Ethics Committee, what are called institutional review boards in some places, IRBs. And I knew nothing about that field. But I quickly was sort of assigned the task of being the chair of that committee. So I had a on-the-job learning, and fortunately learning from him too. But I would start every 2 weeks or months, whenever the committee met, it reviewed a whole bunch of these research protocols, clinical trials, and as a lawyer, that was enjoyable to me because you would have these consent forms, and you're a lawyer, you review documents, you look at the wording of things and that kind of stuff. And so I'd quickly be reading a lot of these, and within the first month or two, I was reading a bunch of them and concluding, gee, many of these were just horrible. I mean, they were hard to understand, and you read it and it was not telling the information you wanted. And I had practiced law before this, as a lawyer, not again in the health field, a totally different field, but I was, in New York City practicing law for this big law firm. So I was used to reviewing documents and knowing what is good or bad language in terms of how lawyers look at it. So it's kind of surprising to me, gee, these are big clinical trials with millions of dollars at stake. How could they get away with writing these documents that were like really bad in many ways from my viewpoint? And eventually I turned that into a book discussing, various aspects of research ethics, particularly about informed consent. So,
Right.
so I still think this is a huge issue in terms of we could do a better job in terms of making sure that people know what's going to happen to them when they enroll in a clinical trial. That's the least we owe to them if we're trying to, again, it is a good thing to do the research. I don't want the work I do to stop the research from taking place,
Right.
but you try to make sure it still fits with our basic ethical standards.
When you talk about clinical trials giving bad consent forms, are you talking about the wordings that they use are very difficult to understand, or what exactly do you find disconcerting?
Okay, so that's an excellent question. There are many types of problems. Probably what many people say is right, a lot of consent forms are written at too high a level so that you need like a college degree to understand it. And what Word has its tests for, it tells you what the wording level is. If it has too many long words and things like that, it gets a high rating. That is a problem in general. Yes, we should simplify the wording of the consent forms, but from my viewpoint, that's not the biggest problem. Often the consent forms will just not have the information that they should have in terms of appropriately disclosing things to people. So, to give you an example that others have written about, and I've written about it a bit too, in some clinical trials, it often is the case. Imagine we're treating people who have bad cancers, okay? You're going to have a standard care arm, which is what the treatment usually would have been if the person wasn't in a clinical trial. And you'd often be randomized 50-50, to getting the standard care or getting to some new treatment that they're testing. Right. Well, often the new treatment is some combination of drugs, chemotherapy drugs that have already been on the market, and often many chemotherapy drugs have been on the market for many, many decades. So they're pretty old drugs, but it could be a particular combination of them has not been tried on this cancer, okay? So the person has this cancer, they're being invited into this clinical trial, and in the clinical trial, you basically electronically flip a coin, and half the time they'd be given the standard care, half the time they get this new combination of drugs, which we don't know whether it's going to help them more than standard care, but it might, okay? And often in these scenarios, standard care is not very good. It's not going to extend your life very much. And if it's chemotherapy, it's not going to make you particularly feel good,
Right.
So that's what we're talking about. So the consent issue for that scenario is, given that these drugs are old drugs that have been on the market a long time, nothing prevents, and this is true in Singapore, and I'm sure in Hong Kong and in the US, in general, the law is such that it would be perfectly okay and legal for any doctor to give the combination of drugs that's in the kind of testing arm in this trial to a patient. Well, if you're the patient and this is a horrible cancer and it's going to probably kill you, unless some miracle happens, you probably don't really want to be randomized to the standard care arm, because you're going to get a treatment that you pretty much know isn't going to do you very much good. Why wouldn't you want to take your only shot and get the new drugs? Well, so if you're enrolling in the clinical trial, half the time you're going to be randomized to standard care. Why wouldn't you want to at least be told as part of the consent, by the way, if you really want the new combination of drugs, you could just go to a doctor and ask the doctor and hopefully talk them into giving it to you.
Right.
This is not a trivial issue if you're sitting there dying of the cancer.
Death.
Yeah, exactly. And yet consent forms, by and large, will often not disclose that fact. And it gets into a complicated thing why, at least in U.S. created consent forms, it gets into the U.S. Food and Drug Administration, the FDA, and it doesn't like that being disclosed.
Right.
So that's a good example of what I think is, it's not an issue of how complex your writing is for that particular provision. It's just you're either saying or not saying something that could be the most important piece of information that somebody would want to know in making a decision whether or not they want to be in the trial.
Right. And do you think this omission is, unintentional because researchers are not trained in research ethics, or is it actually, partially for research purposes?
Yeah, it's certainly not unintentional.
Okay.
This is a thing that's been written about a lot, by many of us over many, many years. As I indicated, there are regulatory issues in terms of like the US FDA actually objects to your disclosing this other option. They will object on grounds that I think are not actually appropriate.
Therapeutic misconception?
No, it's more, it's sort of related to that. They will basically conclude, so we're talking about, often this discussion would be in a section of the consent form where you're talking about alternatives. In other words, if you're considering being in this trial, we're required to ethically tell you what are your other options instead of entering into the clinical trial. And so the question is, what is an appropriate alternative to being in the clinical trial? The option we're talking about is basically an off-label use of existing drugs. Off-label is the technical terminology when you're using a marketed drug for some purpose for which it's labeling, right? This is the legal stuff. If you get a drug, often it comes in a little box with a tube, and then there's this little piece of labeling in that, which is a legal document that explains what ointment or whatever it is could be used for. Same thing with pills or anything else. Well, the rules, the labeling is controlled by whatever country you're in, the equivalent to the Food and Drug Administration, the FDA in the US. And the FDA puts limits on the ability of the people who make these drugs to promote them for something that is not one of the uses that FDA approved to be in the labeling. And so the uses we're talking about here on the innovative arm, these are unapproved uses. There's no doubt about that. So the question is, when can you legitimately allow a discussion of those uses? From my viewpoint, in the consent form is obviously an appropriate and perfectly fine place to discuss it. In fact, it's unethical to not discuss it there because otherwise you're hiding from the person who's being asked to be in the trial. You're hiding a huge piece of information. On the FDA side, they're very concerned often about what they consider inappropriate promotion of an unapproved use, okay?
Right.
And they will claim, well, the trial is run or promoted by the company, often, not always, but often a company that will make one or another of these drugs that are being used off-label, and it doesn't want them inappropriately promoting it. So you get into this back and forth of, is the FDA correct when they're calling this inappropriate off-label promotion? So that's one of the issues here, but that's probably one of the bigger issues that I would, back when I was in Kansas and chairing this IRB, you would often come across consent forms where this was an issue. And back then what I would do is tell the people who were trying to get the trial conducted in our medical center, go back to the lead site, the people who were in charge of the trial, and tell them, why aren't you disclosing this use? And they will quickly, immediately, the ones who knew this would immediately tell me, well, no, they're going to tell us that it's illegal to disclose this use, that the FDA thinks it's a bad thing. And I said, well, push them on that and say, we're not going to approve it unless you disclose it. So they would go back and talk to their lawyers, and every time this happened, it was interesting, they would back down and they would eventually allow the language to be modified.
Really?
Oh yeah, so I'll give them credit for doing that or something.
Do you think it's because of your persuasive power, or you think it's just a convincing argument?
I think it was less my persuasive power in that I was basically saying, we're not going to approve it. I mean, they may have in their heart agreed with the arguments we were making, but they probably still had to go back and kind of, get the approval of some higher up person, a drug company or whatever it is. I don't think they went back to the FDA. They just probably convinced themselves that it actually sounded reasonable to put this language in the consent form, and so they're probably more thinking on were they going to get in trouble with the FDA for including this language. I did try to, in terms of convincing them, I would certainly indicate to them I had done this with other studies where I encountered the same thing. And in general, those people did, make the changes in the consent form.
Right. That's a very interesting example because logically speaking, I would think if you included that in the consent form, it's very likely that less people are
would
going.
Enroll.
Yeah.
Yes.
Is that the case? Do you know if that actually?
Yeah, I don't know. That's a great question. And this is getting back to this core issue of research ethics. And I feel bad sometimes that I'm not trying to discourage people from going into clinical trials.
Right.
Obviously, if we don't get people into clinical, this is a fundamental dilemma of research ethics, that to the extent you do an appropriate job, you're probably making it harder for researchers to conduct the trials. And this is a huge issue in certain types of trials that a lot of us spend a lot of time writing about and talking about. Getting the right balance in terms of, you could actually conclude, so in this scenario, for example, one way to get more people into the trials is basically to change your rules about off-label uses and basically say it is illegal for a doctor to prescribe this on an off-label use. That would actually cause more people to be in the trial because they then wouldn't have an option. You'd either get the 50% chance of it being in the trial, but you wouldn't have the alternative of a doctor giving you to you off-label because you would change the law and basically say that's inappropriate. But that's not all that different than for a brand new drug, okay? For a brand new drug, we don't have a problem in most countries. You cannot get that drug, even though you may be dying of some horrible terminal disease and there's no treatment out there. Your only choice is basically to try this drug, but the law could be that, no, this drug cannot be given to anybody until it undergoes testing in a clinical trial, and that's benefiting our society, because until we have the answer as to whether the drug works or not, we're not going to be able to allow it to be used for thousands, tens of thousands, however many people have this particular disease, cancer, whatever else it is. So you're always making trade-offs against perhaps the best interests of all the patients who are around now versus perhaps learning through clinical trials and then benefiting all these patients in the future. It's sort of interesting because yesterday, actually it was, there was actually a meeting in Singapore of a group talking about expanded access in the Asian Pacific region. Expanded access meaning, in some scenarios, taking a drug or another treatment that is not yet been approved for marketing and giving it to patients. Because it could be the only thing. We're assuming these are like life-threatening diseases. And these are huge issues, and they're often at the heart of research ethics.
Right. So it's very interesting because you sit on an RB board. Is that right? Or you used to?
I used to. Yeah, I used to chair this IRB back in Kansas years
And you
ago.
have multiple roles. You were a researcher yourself. You were a lawyer. Are there ever a conflict in perspectives or interests?
Oh, sure. Absolutely.
How do you balance that?
Yeah, it's difficult. You try to reason through these things and you try to kind of figure out what your rules are or your rules should be in society. So sort of, picking up on what we were already talking about, I'm in general open to changing our laws so that it makes it harder for people to get access to certain unapproved drugs, for example, or an approved drug for an off-label use, if that would improve our ability to recruit people into research studies. I think that might actually be a good change. But while the drug is available as an off-label use, I find it far more problematic, both legally and ethically, to write the consent form and then hide in the consent form the option of getting it outside of the trial. That's why, from my viewpoint, let's view that as a both legal and ethical dilemma, which should require us to change our rules and perhaps change them in a way that kind of forces people to recognize that from their viewpoint, the best option, the best alternative for them is to be in a clinical trial because you've eliminated their other options. Now, I mean, all of this involves interesting discussion of ethics because some people would say, well, it's unethical to change your laws in that way because you're removing an option from these people. But if you believe that, then you shouldn't believe in the laws in the first place that restrict newly discovered drugs. So there, for example, in the U.S., you're probably too young. Steve McQueen was like this famous actor way back when or something, and he ended up getting a cancer, and he went to Mexico to get one of these alternative treatments, and there was a huge legal case back then in terms of whether people who had horrible diseases should be allowed access to quote natural remedies. So this was something you ground up, some kind of nuts or something or whatever it was, and you would turn that into a medicine. And so the question is, should people be able to allow to take that kind of treatment? And in the U.S., the FDA back then often applied rules such that no, this is an unproven treatment. We have the authority to regulate it, even though again the claim was if a person is dying and has no other options, why is the FDA preventing the people from getting access to this? And it was eventually determined that this was part of the FDA's authority. You had a broader question that I don't think the Supreme Court in the U.S. has directly said that much about, which is, was that unconstitutional to, again, prevent people from, it sounds like an intuitively ethical thing. They're dying, they have no other options, let them get access to this. But on the other hand, the more you open up that access is going to make it hard to do the clinical trials that you need to do to determine whether this stuff works or doesn't work.
Right. This kind of prompts me to another question. I always feel like, because I've tried to apply for an RB before, I've looked through an informed consent form, it is quite difficult to understand. And even though sometimes you include information in that consent form, but it could end up being so long, and you just, if you're doing an interview with a participant, you just end up reading the whole script. Right. And it's very difficult for them to catch every single piece of information there. So I feel like sometimes having just a document as a guarantee of, I have provided informed consent is not really ethical. So what do you think? Do you agree with this? And what do you think are some alternative measures that could have ensure that participants are actually accurately informed?
Yeah, okay, so it's a great issue. I'll tie it into, because when I was in the U.S., before I came to Singapore, I was running this regulatory unit, and we actually changed the rules in certain ways. And one of the rule changes I actually am sort of proud of. I think it's actually a good change, and it relates to informed consent. And it's sort of exactly the problem that you're talking about, which still exists, which is that we have these long consent forms, and often when people are invited into clinical trials, they look at it and it's like 30 pages long, and they basically won't read the whole thing, and they'll just ask the doctor or whoever is inviting them to be in the trial, well, what do you think I should do? So that's not good consent at all. So the change we made in the U.S. rules, this was only a few years ago, and it's sort of, people are still trying to understand what it means, was basically that at the beginning of a consent form, you should basically provide the key information. And by key information, it's what are the things that really matter to people in terms of most people deciding whether to be in a trial or not be in a trial. And so one of the key pieces of information is exactly what we're talking about. Would you be able to get the innovative arm outside of the trial? Okay, so risks, benefits, alternatives, those are sort of things that you should be discussing in the first 1 or 2 or 3 pages of the consent form. And often it could be the case that you could actually put that information in a somewhat summarized form in those first few pages, And it wouldn't matter so much whether the person does or does not look at the rest of the form. By looking at those few pages, they can actually make a really good decision most of the time as to whether they should be in the trial. So by tacking on those few pages, you may make the consent form longer, but who cares if they're going to look at the first few pages instead of looking at a 30-page form and totally ignoring it.
Right. It is. I think informed consent is truly a fascinating topic. It was introduced a long time ago, but we're still grappling with more and more different questions and challenges with it. It's really, really intriguing, and
it's hard. Excuse me. It's hard to do well, basically.
It definitely
and so
is.
we always are trying to do a better job. Yeah.
Is that still a direction that you're trying to work on?
Oh,
in the
absolutely,
future?
absolutely. One of the other things that I thought we did a good job on in revising the rules was we required consent forms for trials that the U.S. government funds. The consent forms at a certain point have to be made public. They actually have to be put on a website or one of two websites. And the result of that is, since this went into effect, around like 2018, 2019, there are now about 10,000 consent forms on this website. And before we did this, it was actually hard in many cases to see consent forms because, if you're a big drug company, you do not want people other than the people who you have to get their consent. You don't want, lawyers to see the consent forms because you're worried that maybe they'll sue you, okay? And they could sue you even though your consent form is pretty good, but, you're then, well, do I want to just end this lawsuit by just giving him some money instead of risking that it will go to a jury and the jury will look at the consent form and find some small problem and then force the drug company to pay millions of dollars to research participants. So in any event, we now have these 10,000 consent forms on the web, and people could learn from them and see how good a job we're doing. So people in ethics research can look at them, and now we have AI to analyze large volumes of forms and things like that. And so you're right, there's a lot of possibilities. It's actually an exciting field in terms of looking at research ethics and looking at consent forms. And so you could analyze the alternative sections of thousands of consent forms just by if you know how to do the programming, downloading from this website a ton of consent forms, whereas before 2017 or earlier, if you wanted to do an analysis of like 200 consent forms, there's a really famous New England Journal of Medicine article that analyzed consent forms for phase 1 oncology trials, and this was back in like 2000. It was done by top-notch research ethics people at the NIH, their main clinical center, and this turned into a really important article, and they had a right to researchers around the country to collect like 250 consent forms. So that was a lot of work, okay? But now we have thousands of consent forms that are just there for you to just download and select the ones you want based on what kind of trials you want. So I think that's a really positive development.
Right, and I think all these new discussions about informed consent should be part of the training as a researcher so that they understand, informed consent is not just about that form and the formalities and the kind of specific wordings that you need to include. It's meant to provide information and recruit participants ethically.
Yeah, so you're raising a wonderful issue about kind of forms and the relevance of like a consent form versus the discussion between the researcher and the participant, the person they're inviting to be a participant. And so that's another, what from my viewpoint is a really interesting thing. Often, being in this field, and I write a lot about consent forms, you would get a lot of people who respond, and this is even people in ethics. Well, we shouldn't pay so much attention to the consent form because what really matters is the discussion and the interaction between, again, the researcher and the participant. And I totally agree with that, but the part of it I think some of them miss is that, well, ultimately what this is about is getting certain information to the participants so they're appropriately informed and they have the information they need to make a good decision based on their own values. Because that's what we're trying to do, you shouldn't, undervalue the importance of having a form, because until we reached a point where we're perhaps going to videotape every single discussion between a person you're inviting into a trial, if there isn't a form there, we actually don't know what information the person was actually given. By having forms and having people sign at the end of forms that they were given this form, we actually know at least that the information in that form was appropriately given. So if we were discussing, for example, did this person with terminal cancer know about their option of getting the combination of new drugs outside of the trial, we'd have no clue whether or not, you could do this wonderful discussion and in fact the researcher could have done a really good job of informing the participant, but we wouldn't know whether they did that good job or they did a horrible job and never told them about the out of trial option unless we had some way of documenting it. And it just so happens the cheapest cost-effective way of documenting conveying information, which we do all the time in the real world, is writing it down and proving that the person was given the information. And that's why in many things, you buy a new PC game or something, you have you're allegedly reading this massive amount of information that you're clueless about what it means. But hopefully in research ethics, we really want to do a good job. We don't want it to be like the forms you get all the time when you take some new app that nobody reads those things. This should be an outlier that actually we want the people to read the things, at least the key information, and hopefully it'll be very understandable. And so that's the other element of the opposite of these legalistic long documents that you click on every time you agree to the new app. This is just the opposite. Let's make sure it's understandable. So, and that's always the challenge. How do you convey stuff so people really understand what's at risk? Because it could be their life or something, right? It's not some app that you'll enjoy playing for 10 hours or something. Right?
Would you call this informed consent form a type of procedural justice? Is that the right?
I would use it in terms of it's a procedure that matters, right? Because there are reasons why we follow certain procedures. We could go to the extent of basically, again, videotaping these conversations. And interestingly, that happened in India for a while. There was a lawsuit in India where some bad thing happened in a particular clinical trial. So like the highest court in India changed the rules and basically ordered all research that you actually, when you got consent, if it was a non-trivial trial where there were actual substantial risks, you had to videotape the whole process. And eventually the government in India rewrote the rules so that you only need to do the videotaping in a much smaller percentage of the cases. I think a lot of people were freaking out, particularly in India, when they were videotaping all these. Right. And even if you videotape it, in a sense, that's actually in some way not as good ethically as having the consent form, because you videotaped it, but you still don't know what was said unless some outside person spends all the time in going through the whole videotape. Whereas in the consent form, as long as we know this is an official version of the consent form that the person was given and signed, the content of that. They were told about their option outside of the trial. If all you had without the procedural benefit of the consent form was a videotaping, you wouldn't know what was told. So yes, I think your point that this is a procedural protection, and it just so happens that by putting something in writing and making sure this is the version that people get, and of course in consent forms we track versions very scrupulously, so they often are stamped by the IRB at the bottom of each page and that kind of stuff. So yes, it is an absolutely good procedural protection, and in many ways, even though you may think it's very low tech, it's a piece of paper, but that is the standard
It does its
way.
job.
Does its job. It's cost effective. You're right. It's cheap. So I think that's my response, because I would get these arguments from people all the time. Why is it you're just, you're not really into ethics? Why are you worrying about pieces of paper? We should worry about the process. We should worry about the conversation. And my response is, I don't know what this person was told in this conversation. At least with a piece of paper, I will always give them the example. Some trial for infants or things like that, and then we're trying to figure out, well, of course the parents want to protect the infant. If you write a consent form that on the first page says, this trial is not going to benefit your infant, in large print, okay, on the top page of the page, and then below it you say, and by the way, it will impose the following risk on your infant, and you state that clearly, you're not going to have a problem with good consent. A mom who reads that, will quickly decide whether or not she's okay with exposing her infant to that risk. So often we'll say, well, it's really hard for people to understand this. That's why we have 30-page consent forms. I often just disagree with that. It's more that we're not willing to be upfront enough. Now, and that's a more complicated issue of, right, if it's a trial in which it doesn't sound like it's a really wonderful thing for somebody to be in this trial, you're going to have a hard time recruiting people. So these are the dilemmas that we wrestle with in the field. And yes, in terms of different roles, like I said, I believe in research. I'd like to encourage as much research to take place as possible. But then we have to figure out, okay, what are our ethical rules in terms of what we should tell people? And often the appropriate response from my viewpoint is, it's not good to hide stuff from people if in fact they should have a right to know that. And if the result is that you're not going to get people in the trial, maybe we should change the rules about what they have access to outside of the trial. A wonderful example of this is what happened in COVID during the pandemic. In many places, including the US, people were allowed access to some of the newly created convalescent plasma, for example, when they took, blood serum from people who had already been infected with COVID and turned it into a treatment. Before they actually had proof that it actually worked, they hadn't completed the trials. In the US, the FDA played a role in basically allowing emergency use of this. So you suddenly had hundreds of thousands of people getting the convalescent plasma, and you weren't getting enough people enrolling in the clinical trials. That was not a good rule, okay? You, again, do what you have to do, perhaps in tweaking the legal rules in terms of access to an unproven product.
Right. Yeah. Consent really is a very complicated topic, and it's been a very meaningful discussion, Jerry. It's I think we touched on one of the more complex issues about research ethics, which is informed consent. And yeah,
my pleasure.
Thank you for your time.
Great discussion.
It's a great discussion. We're very
Thank you.
knowledgeable on this.